This video was submitted to the administrators of our group as a post. I delayed posting it because I felt somewhat out of my depth and sought advice from a friend who is a criminal lawyer, which I now have and is the reason I post it now. In the opening sequence, our commentator, Alistair, appears to reread from the 1852 New Zealand Constitution Act, which, quoting my friend, was an act passed by the UK government setting up a Westminster-style government in New Zealand. An important point my friend also made is that what we must bear in mind is that issues of independence, democracy, and indeed government in the history of New Zealand were evolutionary.
So that was Section 71 of the 1852 Constitution Act. And I'll just read that again. And whereas it may be expedient that the laws, customs and usages of the Aboriginal or native inhabitants of New Zealand, so far as they are not repugnant to the general principles of humanity, should for the present be maintained for the government of themselves in all their relations to and dealings with each other, and that particular districts should be set apart within which laws, customs or usages should be so observed.
I'll interrupt here to give a little more background on this act. Other sources, such as www.parliament.nz, have this to say. The New Zealand Constitution Act 1852 established New Zealand's parliament. It is one of the longest continuously operating parliaments in the world. Other comments in the document? Although New Zealand doesn't have a single overarching constitutional document, we certainly have a constitution. Here's a commentary from Wikipedia. The 1852 Act was an act of the Parliament of the United Kingdom that granted self-government to the colony of New Zealand, also claiming it was superseded by a later act of the New Zealand government with the words, quote, "It was repealed by the Constitution Act 1986. However, my friend disputes the accuracy of that phrase because a completely different parliament cannot repeal another government's laws. It is more accurate to say that the Constitution Act 1986, brought about by the New Zealand Parliament, rendered the 1852 Act by the British Parliament redundant. The Wikipedia article now reflects more accurately what took place. Further evidence that the 1852 Act construed by the UK government is now defunct is furnished more accurately by the later New Zealand Constitution Act 1986 itself, where in the opening statement it cites, and I quote, that the New Zealand Constitution Act 1852 of the Parliament of the United Kingdom shall cease to have effect as part of the law of New Zealand. Unquote. The article in Wikipedia has been researched and its notability has been established. Another significant comment from the article, the long title of the act, was an act to grant a representative constitution to the colony of New Zealand. The word representative signifies the birth of democracy in New Zealand, which got royal assent in 1852.
And it goes on a little bit, but that first part of it is really the important thing there.
So if you'll recall, Alistair is attempting to make an argument by quoting from an act made by a British Parliament that is now, quote, ceased to have effect, unquote. The particular Section 71 that he quoted in particular also has its own unique set of shortcomings. Alistair appears to be intent on building a case for Maori sovereignty from the defunct Act Section 71 of 1852. Additionally, there is an important distinction between what is merely an enabling provision and what is actualized, something carried into effect. This is of great significance to the argument in the video. Where Alistair speaks of Section 71 of the Act, Maori districts were allowed for under the Constitution Act, where Maori law and custom were to be preserved, but this section was never implemented by the Crown. It was, however, used by the Kingitanga to justify claims of Maori self-governance during the 1870s and 1880s, from the Wikipedia article that I've already referenced. My lawyer friend says, if it was never carried into effect by the issue of letters of patent, then that is the important point and is a simple answer to Alistair's discussion. This is the preeminent issue. So how can Alistair's argument be supported by a statutory provision which was only ever enabling, creating a power to do something, but was never acted on and is no longer part of our law? From the New Zealand Constitution Act 1852 itself, Alistair quotes verbatim from the section of the 1852 Act. And whereas it may be expedient that the laws, customs and usages of the Aboriginal or native inhabitants of New Zealand, so far as they are not repugnant to the general principles of humanity, should for the present be maintained for the governments of themselves and all their relations to and dealings with each other in that particular should be set apart with such laws, customs and usages should be so observed. Yet here again, in terms of the expressions used within the overall context of the Act, nothing in this detracts from the overall sovereignty intended and exercised by the Crown over Maori affairs. If you look at the words expediency, what does it mean? It means the quality of being convenient and practical, despite possibly being improper or immoral. Convenience. So it was expedient that the laws and customs of the native inhabitants should, for the present, be maintained for the government of themselves. So clearly this was not a permanent solution, but a temporary expedience. So it indicates the ultimate intention to exercise full sovereignty over all matters, but over such period of time that they can be implemented without undue resistance as the Maori people adjusted to the new reality. From this, we glean that in matters of lesser importance, the overall daily running of Maori affairs was not, at least for the meantime, to be meddled with as a cause of unnecessary stress to the new relationship forged by the treaty. Although not explicitly making the claim, it appears his reference to this Act and these particular parts of it, where reference is made to the preserving of Maori law and custom, is somewhat misleading. Ceding Maori sovereignty was a prerequisite, the main thing. Preserving Maori law and custom was not a commitment by the Crown in any legal sense, nor was it required. However, in certain respects, a blind eye had been turned towards a very limited form of self-governance. However, the indulgence of self-rule by Maori was only in regard to certain respects of Maori custom and as a matter of temporary expedience. The question must be asked, if it was the case that overall sovereignty was neither expected nor ceded to the Crown, then why did the Maori King movement get utterly rejected by many of their own people? The setting up of a Maori king was roundly condemned by many chiefs, I believe around 200, at the Kohimarama Conference of 1860, when it went on public record that they unanimously declared the rival authority chronicled in a dual language publication called The Maori Messenger and described as the project of setting up a Maori king in New Zealand a cause of strife and division and is fraught with trouble to the country. That Great Britain was indeed sticking to its original commitment to bring Māoridom under British law in as gentle as fashion as their culture could bear, leaving for the time being Māori free to exercise chiefly control over their own, and in accordance with their own ways, is evidenced early on in the instructions of Lord Normanby as authorised by the British Crown to her envoy in New Zealand, William Hobson. And I quote, "The establishment of schools for the education of the Aborigines in the elements of literature will be another object of your solicitude, and until they can be brought within the pale of civilised life and trained to the adoption of its habits, they must be carefully defended in the observance of their own customs so far as these are compatible with the universal maxims of humanity and morals. But the savage practices of human sacrifice and cannibalism must be promptly and decisively interdicted. Such atrocities, under whatever plea of religion they may take place, are not to be tolerated within any part of the dominions of the British Crown." This is from the Treaty of Waitangi.net.nz, Lord Normanby's brief, HTML. An interdict is an authoritative prohibition. Overall, British law would prevail. Notwithstanding this, though, Māori in part were left to manage their own affairs according to their customs and laws to some extent, and only in respect of issues of a lesser nature, though the law did not require this, nor was it responsible for preserving it. Halsbury's Law. The next reference our video host makes to the third edition of Halsbury's, which, according to Wikipedia, was published between 1952 and 1964. At the time of writing, this cannot be verified as no access was available to the publication, and therefore the context of the references not able to be observed. However, I quote the advice obtained from my friend. The typewritten document which he, Alistair, puts on screen does not purport to be Halsbury's because it refers to Halsbury's in the text. So we do not know the commentator who has written clauses 12 and 12.1. Alistair is commenting on another commentator who comments on Halsbury Law, which after all was itself a commentary, albeit a highly authoritative one. And I quote my friend again, "The commentary, which is screenshot in the video, states that a Westminster Parliament can repeal its own laws, but one Parliament, i.e. one in the UK, cannot overrule another Parliament, i.e. in New Zealand." The crux of his argument appears to be the reference to the Maori Parliament at Waitangi.
William IV's Parliament was the House of Lords, and his court, the main court that he was working through, is the Privy Council. And the House of Lords has a set of books where most of the documentation is recorded. It's called Halsbury's Law. And what's significant within Halsbury's Law, and I'm just going to read out a passage, and this is from the third edition, volume 36 of statutes. It's a bit much here to remember, but I'm giving it to you anyway. Paragraph 559 at page 337. It says, section 12.1. New Zealand Parliament cannot derogate from the sovereign supremacy of England. So New Zealand Parliament cannot take away from the sovereign supremacy of England. And England cannot derogate from the sovereign supremacy of the Maori nation assembled in Parliament at Waitangi. So for the record, we know where the highest court on this land is located. It's located in Waitangi. And on the 28th of October every year, a Whakaputanga is celebrated. The proclamation of sovereignty is celebrated. And interestingly, that on the 6th of February every year at Waitangi, the Navy are obliged, they're obligated.
Obligated to the 21 gun salute under King George IV. That's where the handover went into Queen Victoria. All authority from King William IV. Sailor boy, they call him. Commander of Chief of the Navy shipyard there. You got two different literacies, the Chief of Commander and Commander of Chief, but King William IV, they don't realize that they're obligated.
Obligated.
As a part of the contract, is that right?
That's right. Morena, everybody.
Morena.
Thank you, Kapa.
Thank you very much.
They fire a 21-gun salute to Kara, the flag that was brought here as a gift and as an acknowledgement of the sovereignty from William IV. Because if I go back to Hallsbury, remember Hallsbury's law from House of Lords? It says very, very clearly, I'm going to read this again. New Zealand Parliament cannot derogate from the sovereign supremacy of England, and England cannot derogate from the sovereign supremacy of the Maori nation assembled in Parliament at Waitangi. And following the principle found in K, and I'm not going to go back up there, a statute does not need to state that it cannot be repealed, because once put in force, it cannot be repealed by any later Parliament. Its provisions can merely be brought forward into current legislation because a later Parliament cannot derogate from its forefathers' legislation. So we know that the 1852 Constitution Act stands. It is the only Constitution Act.
To quote my lawyer friend, if so, he needs to state that clearly by revealing the full commentary from which he is quoting. He then needs to make his argument why that validates the idea of a Maori parliament, whether in Waitangi or anywhere else. There has never been such a Maori parliament in the Westminster sense, and certainly none existing between 1952 and 1964 when the third edition of Hallsbury's was written. End quote. The conditions ruling intertribal relations up to 1840 were such that in the lead-up to the Treaty of Waitangi proposal in Lord Normanby's instructions to Hobson, it is clear that though he Whakaputanga, the United Tribes Declaration of Independence of 1835, was recognised as Maori sovereignty over New Zealand, it was yet a tenuous acceptance of limited Maori unity, far short of nationhood or organised national governance. The expressions therein regarding Maori, quote, whose title to the soil and to the sovereignty to New Zealand is indisputable and has been solemnly recognised by the British government, expresses the acceptance of sovereign rights up to the signing of the treaty, while at the same time the reservations about Maori being able to set up a proper governing structure were also evidenced just a little later in those same instructions to Hobson. I have already stated that we acknowledge New Zealand as a sovereign and independent state, so far as, at least, it is possible to make that acknowledgement in favour of a people composed of numerous dispersed and petty tribes who possess few political relations to each other and are incompetent to act or even deliberate in concert.